and members, and I appreciate the very calm nature of our debate today. We are here today talking about an important piece of legislation that is about reproductive freedom and each individual's autonomy in making their own reproductive decisions. My amendment clearly states that language. That's simply what it does. I think it is important that we are crystal clear and would like to add this amendment to the underlying amendment, and I'd ask for your vote.
A roll call was requested and a roll call granted. Any discussion on the A204 amendment? Senator Abler.
Mr. President, it's not posted yet, so I don't know how to comment.
I'm sorry, can you?
It's not, is it up now? Okay.
Members, can I ask for all side conversations to be quiet just so I can hear? I'm sorry. Senator Abler, one more time.
Mr. President, I would, it was a pretty good amendment that we had before, Mr. President. And this actually makes it a much worse amendment. And so it kind of just is duplicative to the bill, continues the theme of all abortions all the time. The point of the amendment to the amendment was to clarify, and I guess I have to say that Senator Murphy has clarified, but it doesn't do anything to put any safeguard around any of the guardrails this bill needs, and so I would urge members to vote no. Thank you.
So any other discussion on the A204 amendment? Senator Johnson.
Thank you, Mr. President. And if I may ask Senator Murphy a question.
Senator Murphy will yield. She will yield, Senator Johnson.
Thank you, Mr. President. And Senator Murphy, I just wanted to read out your amendment here. The state shall not interfere with an individual's autonomy in making their own reproductive decisions. Yet in Minnesota Statutes 256B.001, we have a statement in here that says between normal childbirth and abortion is the state's policy that the state of Minnesota, that normal childbirth is given preference and encouragement and support by law and state action. It is in the best interest of the well-being of the common good of the state of Minnesota citizens. Can you square this one with me? They seem to be two very contradictory angles on this, and we'd have quite a split in state law if this one actually got on and became part of the bill.
Senator Murphy.
I appreciate that question, Mr. President. Thank you, Mr. President, and Senator Johnson. I appreciate your question, and of course don't have the citation in front of me. But what I do know is in Minnesota today, a person has the ability to make their own reproductive choices, when to start their family, to carry their pregnancy to term or not. Our debate today is about codifying what has been in case law and to make sure that that choice, that autonomy remains ours as a private decision, a private medical decision, and my amendment to this amendment restates that.
Senator Lang, for what purpose do you rise?
Well, thank you, Mr. President. I just would like to see if Senator Murphy would yield for a question.
Senator Lane, I can't call on you. The floor belongs to Senator Johnson unless he's done. Senator Johnson is done. Senator Lane.
Thank you, Mr. President. If Senator Murphy would yield.
I'm sorry?
If Senator Murphy would yield.
Senator Murphy, will you yield? She will yield. Thank you so much for asking.
Thank you, Senator. I was just wondering, looking at if you would consider an oral amendment as a friendly amendment in taking the word reproductive out and replacing it with health care. We've talked a lot over the last few hours about this being health care. Why would we not have those two terms interchangeable? And I would
Mr.
offer
President?
that oral amendment and see if Senator Murphy would be amenable to it.
So, two things. One is, Senator Lang, we are on an amendment to the amendment, so we cannot do an oral amendment. That is not proper. And Senator Disick, you rose with a point of order, so I just wanted to make sure that you were clear on that. I know she said Mr. President, and I was going to see what she was going to say. So sorry about that. So Senator Lang, your amendment to the amendment isn't appropriate.
Mr. President, I agree completely, and in fact, that's why I was bringing it up with Senator Murphy, if she would offer that amendment to her own amendment or withdraw this amendment with that terminology in it. I think she'd probably have some Republican votes. Thank you, Mr. President.
So are you asking Senator Murphy to yield to that? Senator Murphy.
Thank you, Mr. President, and thank you, Senator Lang. I'd ask the body to vote on my amendment to the amendment as it is drafted.
All right. So it doesn't sound like that's going to be friendly there. So are you rising for a point of order, or you have thoughts on the A204, Senator Pratt?
Thank you, Mr. President. I would move that the A204 amendment is not germane under Rule 35.2. Mr. President, as Senator Abler has been offering amendments to the amendments, they've been additive to the underlying amendment, which deletes the terminology not limited to. Senator Murphy's amendment not only deletes Senator Abler's change, but then adds additional language, and therefore, if you want to delete the language that Senator Abler has offered in the A51, we'll be taking a vote on that. But this is substantially different than the underlying amendment and should be ruled not germane.
Senator Pratt raises a point of order under Rule 35, just to make sure. Yep, Rule 35.2 after germaneness. Any further discussion on that issue? Advice? Senator Murphy.
Thank you, President Champion and members. As I look at the rule that Senator Pratt is making reference to around germaneness, that would be 35.2, and his listening to his argument that my amendment to the amendment substantially changes the proposal, I would disagree strongly and respectfully that the language in my amendment to the amendment does not substantially change the nature of this proposal. It is in line with this proposal, and therefore I would ask that we vote the Pratt motion down.
I'm ready to rule.
Advice, Mr. President.
Mr. President.
Okay. So Senator Pratt, and then we'll go to the majority leader.
Thank you, Mr. President. The A204 undoes the only change in the underlying amendment and therefore substantially changes the intent of Senator Abler's amendment, where previous amendments to the amendments have been additive to the underlying language. And so by adopting the A204 and deleting that language, it substantially changes the underlying amendment, and I ask you to rule in favor of the motion.
Senator, all right.
Mr. President, I was standing over here.
Oh, is this to this issue here? Yes. So he was on the list first. Senator Lucero.
Thank you,
And is this advice because I'm ready to rule?
It's advice to you on the rule, on the motion.
Okay. Thank you.
Thank you, Mr. President. So as I am looking at the Abler amendment to the amendment, and then I am looking at the Murphy, no, it's the Abler amendment and it's the Murphy amendment to the amendment. I don't see any portion of the Abler amendment that is retained in the Murphy amendment to the amendment. Zero portion of it. And so it looks to me like this is the equivalent of a delete all. Now, Mr. President, we have been moving faster. There's been a lot of people. Can you just confirm for me, point of parliamentary inquiry, Mr. President, are we on the A64 Abler amendment? Let me ask the question a different way. Is the Murphy here, is the Murphy The Murphy A204 is seeking to amend the A51. Is that correct?
That is correct.
Okay. Then I withdraw my advice, Mr. President. I am
Thank
looking
you.
at the wrong amendments. Thank you.
So I'm ready to rule. Senator Jaskowski?
Thank you, Mr. President. Just a question is, Mr. President, as you look at this amendment, can you tell us, is this effectively a delete all amendment?
So, Senator Jaskowski, the amendment speaks for itself. I don't think it's appropriate for me to answer that question. If you look at the amendment, it tells you exactly if it's a delete all or if it's deleting or inserting. I'm sure that you have the ability to read that. You're pretty smart.
Okay, thank you, Mr. President. And it does look like a delete all amendment to me. Thank you, Mr. President.
I've listened to all the advice. I am concluding that the point of order is not well taken. Senator Rasmussen.
Thank you, Mr. President. I would move to divide the Murphy amendment.
Senator Rasmussen is moving. Senator Rasmussen, how would you divide it?
I would divide the amendment between lines 1.3 and 1.4. He's got to report it first.
Thank you, Senator Rasmussen. You said that you want to divide. A secretary will report the division. Do you need to report the division? Okay. Oh, I can just do it. Okay, thank you. So you want to divide between lines 1.3 and 1.4. So you want there to be a separation there. Senator Murphy, which portion would you like to take up first?
Thank you.
Mr. President?
Senator Frentz.
Thank you, Mr. President. On the motion to divide, I would request a roll call.
Roll call has been requested. So, Senator Friends, when it comes to a division, there can't be a roll call under those circumstances. I just have to rule whether it's divisible or not. I did take counsel and we did look at it, and it is divisible. So we will take the portion that Senator Murphy wants to look at first.
Mr. President,
Senator Pratt, for
Thank
what
you.
purpose do you rise?
Mr. President, I just have a question for the President on procedure. Is it the author of the amendment that gets to choose the which section we go first, or the person, the member who requested the division? I thought it was the member that requested the division got to choose which portion was debated first.
Thank you, Senator Pratt. It is the author of the amendment.
Mr. President,
And that would be Senator Murphy
Mr.
in this
President,
context.
can you at least show me where that citation is, please?
If you give me a moment, we will take another look. Senator Pratt, we could look it up. That's been the custom of the body. If you want us to take time in order to do that, as opposed to get to the underlying issues that we need to deal with in real time, that is totally up to you.
Mr. President, it's my recollection under custom and usage that we've allowed the member making the motion to decide which portion of the amendment we would debate first.
First of all, Senator, just so that I'm clear, I was trying to say something to the secretary. It's not a motion, first of all. It's a division. So it's not considered a motion. So to the point, do you want us to stop and do some additional research to see who should go first, who should make that decision? Is our understanding based on custom and usage, it is the author of the amendment. Because it's their amendment. Senator Rest.
Thank you, Mr. President. I just want to confirm your memory of what is custom and usage in the Senate about who has the privilege of deciding which part of an amendment for which division has been requested gets to make the decision, and it is the maker of the motion on the amendment, not the privilege of that person who is requesting the division.
Senator Pratt.
Well, thank you, Mr. President, and I would very rarely disagree with my esteemed colleague on the rules, but I would request that we do find the citation because, again, I have a different recollection of how we've operated over the last 6 years.
So, Senator Pratt, here's my decision. As you look at Rule 39, which is division of question, it does not speak specifically to who has the right to divide that question. Based on custom and usage, I am determining that it is the author of the amendment who has that right. Senator Murphy.
Thank you, Mr. President and members. I would like us to take up the second half of the divided amendment, beginning on line 1.4. I'd ask for a roll call and a yes vote.
A roll call has been requested. A roll call has been granted. The secretary would take the roll. And remember, members, we are voting on the second part of the amendment starting at line 1.4. Senator Kunesh, those voting under Rule 40.7.
Thank you, Mr. President. Senator Fa votes yes.
Senator Parr votes aye. Senator Jasinski, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Miller votes no.
Senator Miller votes no. All those, the secretary may close the roll. Seeing 34 ayes and 33 noes, the amendment is adopted. The amendment to the amendment, excuse me. We are now on the first half of the amendment.
Mr. President?
Senator Rasmussen.
Mr. President, I'd call point of order. This amendment is not germane. It simply deletes the underlying amendment.
Senator, sometimes I have a difficult time hearing up here just because of the acoustics. Would you be so kind as to re-articulate what you just said?
Thank you, Mr. President. The first part of this amendment is out of order, so I'm making a point of order. It is not germane because it just deletes the underlying amendment.
Well, my decision is that it still is on the underlining amendment, and it still reflects that we are talking about this bill. Therefore, your point of order is not well taken.
Mr. President.
Senator Pratt.
Part of inquiry is that anytime there's a a point to be discussed. And once the amendment was divided, then it became essentially two separate questions. And what Senator Rasmussen is arguing is that that if you were just to take this divided piece on its own, it is not germane because all it does is effectively take the vote.
Senator Pratt.
Mr. Chairman, Mr. President, point parliamentary inquiry.
I challenge the ruling of the president.
So, no, well, you had to do that in immediate time, and you didn't do that in immediate time, and you were, and your point was not well taken, and that was already concluded.
Mr. President?
Yes. Senator Rasmussen.
I appeal the ruling of the president.
Well, it needs to be immediate. It wasn't immediate. According to our rules, it has to be done right away. It was not done right away. Senator Pratt started going a different direction, so it is not appropriate. Next, Senator Abler, we are on the underlining A51 amendment.
Mr. President, to the amendment.
I'm sorry. The A204 amendment. Please accept my apologies.
Yes, in the first portion. Mr. President, this is particularly useful language, and taking it out will be helping the bill to be made less clear. And I think more specific is better, and so I urge members to vote no against the first portion of the amendment. Thank you.
Senator Murphy.
Thank you, Mr. President. Members, I would just ask members to vote yes on the balance of this amendment, and I'd ask for a roll call.
Roll call vote has been requested. Roll call vote has been granted. The secretary would take the roll. Senator Jasinski, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Miller votes no.
Senator Miller votes no. Senator Kunish, those voting under Rule 40.7.
Senator Fa votes yes.
Senator Fa votes yes or aye. The secretary will close the roll. There have been 35 ayes and 32 noes. The amendment to the amendment is adopted. Senator Pratt.
Thank you, Mr. President. I'm not sure if I have a parliamentary inquiry or point of order, but Mr. President, I had tried to rise in order to provide you advice before ruling. I understand your desire to keep the proceedings moving along. However, we are debating very important issues here today. I think you've been a little quick in not recognizing members and not recognizing advice, trying to rule before members have been able to give you advice, and I'd ask you to be a little more measured in your pace.
Thank you, Senator Pratt. Just so that there's clarification, and I'll get to Senator Lucero because you are next on the list. There's a difference between a point of order and a point of inquiry. It's different when you think in terms of the action. I have been very patient. I've called on some people 4, 5, or 6, or 7 times. So I don't think that I've been quick. I've been trying to be thoughtful, and I would ask everyone to try to be thoughtful around their thoughts and comments, and I'll try to do the same. Senator Pratt, I don't want to keep going back and forth about this.
Well,
Okay.
thank you, Mr. President. I'm just asking that you provide the minority the opportunity to give you advice on questions like Senator Rasmussen's before ruling. I had tried to stand up and provide advice to you before you ruled. I did not realize that by trying to give that advice as a rationale for requesting a challenge or appeal of the President's decision would in fact invalidate it. But I would ask that you do, before moving on, provide the minority a chance to give advice on when some of these motions are made.
Thank you so much. Senator Lucero was on the list, Senator Abler. Senator Lucero.
Thank you, Mr. President. So now that the amendment to the amendment has been adopted, I was wondering if Senator Murphy would yield for several questions.
Senator Majority Leader.
Senator Murphy.
Senator Murphy, will you yield? She will yield. Senator Lucero.
Thank you, Mr. President. And earlier when I was standing up to offer advice, I had the wrong Abler amendment in front of me. And so I was going to make comments that it is the amendment to the amendment was a delete all, and in fact it actually turned out to be the case. And now that that has been adopted, the first question I would ask here, as I'm reading now the language that has been adopted, the state shall not interfere with an individual's autonomy in making their own reproductive decisions. The first question I have for Senator Murphy is there any definition in specific regards to age on the word individual?
Senator Murphy.
Thank you, Mr. President. And Senator Lucero, no.
Senator Lucero.
Thank you, Mr. President. Okay, so then if there's no definition of individual, then that means naturally that would be individuals of any age, including minors. That is a great concern to me, Mr. President, because the continuing on of this, it says have autonomy in making their own reproductive decisions. My second question for Senator Murphy is
are you asking her to yield, Senator
if
Lucero?
she would yield, yes.
Senator Murphy, will you yield? She will yield. Senator Lucero.
Thank you. Is there a definition for your language that has been adopted for reproductive decisions?
Senator Murphy.
Thank you, Mr. President, and thank you, Senator Lucero. We are talking today about an important piece of policy in House File Number 1, in which we are enshrining in statute what is already in case law in Minnesota, which says that an individual, a person, is able to make their own reproductive choices for themselves. That is an expression of autonomy. It is an expression and an extension of the deeply held belief that we get to make our own private medical decisions. That's what this amendment says. I thank you for your question.
Senator Lucero.
Thank you, Mr. President. If Chair Murphy would yield again.
Senator Murphy, will you yield again? And this is still to the underlying amendment. Yes. I liked it. I don't realize that we have facial expressions, but it's yes. Senator Lucero.
Thank you, Mr. President. I appreciate that answer, Senator Murphy. Unfortunately, you didn't answer my question. My question is, now that the language has been adopted, what is the definition of reproductive decisions?
Senator Murphy.
Thank you, Mr. President, and Senator Lucero. Those would be the decisions about my or a person's reproduction.
Senator Lucero.
If she would yield again, Mr. President.
Senator Murphy, will you continue? Will you yield again? Yes.
Thank you, Mr. President, and thank
Senator
you,
Lucero.
Senator Murphy. Would that include then a vasectomy?
Senator Murphy.
Mr. President and Senator Lucero, we are talking about a person being able to make their own autonomous private medical decisions. The question about whether a person wants to have a vasectomy would be a decision between a person and their provider. And that would certainly have repercussions on a person's ability to reproduce.
Senator Lucero.
Thank you, Mr. President. I heard most of what she said, but she trailed off there at the end. I wasn't able to hear the last few words, so if she would yield again.
Senator Murphy, will you yield again? He said that your voice tapered off. So if I can remind the members to make sure they're speaking directly into those mics and use your outside voice. Senator Murphy.
Mr. President, is there a question?
Senator Lucero.
Thank you, Mr. President. So yes, the question is, I'm trying to get clarity on what the definition of reproductive decisions means. I don't see that definition in the language that's been adopted. I don't see that definition in the underlying bill. And so my question is, would a vasectomy be included in the verbiage that you offer that's been adopted as reproductive decisions?
Senator Murphy.
Thank you, Mr. President, and thank you, Senator Lucero. Again, we are talking about an individual's ability to make their own private medical decision, and in this case, around their choice in reproduction. A person's choice about a vasectomy is a choice that they would make with their provider. It would impact their ability to reproduce.
Senator Lucero.
Thank you, Mr. President. Okay, I appreciate that clarification. So in all of that, I think a simple yes would have been sufficient, and that's what I gleaned from that. So here's what we have, Mr. President and members, is that the language before us includes the word individual with no age restraints at all, and it includes the verbiage reproductive decisions, which has no definition at all. It's very subjective. So as I'm looking at this, we know, and we have a long history and many statutes that seek to protect minors. Minors, those under the age of 18. We have all kinds of limitations. One such limitation is a minor under the age of 18 cannot get their ears pierced without parental permission. We recognize, as a real estate agent, a minor, somebody under 18, cannot sign a contract, a legally binding contract of any kind, which is what a purchase agreement is, but there are obviously all kinds of contracts. They're not binding with the minor's decision. Another example would be voting. We recognize here in the state of Minnesota that somebody under 18 can't vote. Now, why is this, Mr. President? It's because we recognize that there is a period in a person's life when they don't understand the full gravity of the decisions that they're making. We recognize in multiple portions of law that a person needs to have the consent of an adult or guardian to help them understand decisions. Or again, in the case of the ear piercing, because they may not fully understand. In the case of voting, we recognize that life experience means something, which is one of the reasons why, for example, our United States Constitution has a requirement that a person be at least age 35 in order to run for president. So my point is, age has meaning because it brings experience. Then when I get to the portion of the reproductive decisions, vasectomy is a reproductive decision. So under the language that's been adopted, we now have a scenario, if this were to be passed into law, that a minor boy, age 12, age 14, could make the reproductive decision to get a vasectomy. That is very concerning to me, without parental consent. Yet that same boy would have to get parental consent to get an ear piercing. I go on as I think reproductive decisions, and there are all kinds of scenarios. Another might be a sperm donor. Another might be, and it's not my intent to get vulgar, but there are scenarios where a minor might believe it upon themselves that a reproductive decision of their own making would be that they need to engage in pornography. And so, as the language now reads, the state shall not interfere with the individual's autonomy to make their own reproductive decisions. That could very well be interpreted that a minor could not be prevented from accessing pornography. And we wouldn't want that because it says the state shall not interfere. Because a minor boy or girl may want to make a decision that they want to reproduce at the age of 15, and as part of their reproducing efforts, they want to engage in pornography. This, Mr. President, is so extreme. It shocks the conscience of what's being proposed here. It overturns decades of Minnesota principles to protect minors who don't understand the gravity of their decisions. And we should absolutely not support this extreme language. So, Mr. President and members, please vote against the amendment as amended. Thank you.
Senator Abler to the amendment, and then we're going to vote. I think you are the, oh, well, go ahead. Senator Abler.
Thank you, Mr. President.
Oh.
Everybody wants to talk.
I know. I see. Senator Abler and then Senator Makeway.
Well, thank you. And to the amendment, I just want to, I don't know if the author really is what she wrote down. The state shall not interfere with an individual's autonomy in making their own reproductive decisions. I asked her before, I asked Senator Murphy before about when does an individual get human rights? This actually says never. Because as I chatted with actually my son, he was pointing out that this allowing abortion from the whole time, particularly past 20 weeks to the day before the baby is born, is really just a matter of a few minutes and a little skin between life and not life for this little one who's at 39 weeks and 6 days or sometime way at the end. And it says the state shall not interfere with the individual's autonomy in making their own reproductive decisions. And so when we've been privileged to have 6 kids that survived and 3 that did not. But we watched them come along, and we didn't do ultrasounds much, but the little, Barb could feel the baby kicking, and I did a little bit. I wasn't that good at that part, but she fell in love with her little guys. They're all guys except for one of the girls that we lost, but. And the feet kick out, and they're turning, and so you just really feel the vitality. And so when one of my sons mentioned it's just a matter of a few minutes and some skin, literally between life and then reproductive freedom to not have that little baby not live at some late time. And people will say, oh, they never do that. Actually, they do. They do. With this new expanded late time, there's a place in New York I could burden the body by passing out a flyer or an article about a company that's coming in to do 30 weeks plus abortions. And Mr. President, this takes away all the rights of this individual, and it really troubles me. Mr. President, I will move the A65 amendment.
Senator Abler moves the A65 amendment. The secretary will report the amendment. And just a gentle reminder, members, let's make sure that we sort of limit our comments to what's before the body, just so we don't lose track as to the great points that you are trying to make. Secretary will report the A65 amendment.
Senator Abler moves to amend the A51 amendment to House File Number 1 as follows. This is the A65 amendment.
Senator Abler to the A65 amendment.
Thank you, Mr. President, and I would request a roll call.
Roll call vote has been requested. Roll call vote has been granted. And again, this is an amendment to the amendment.
That's correct, Mr. President.
Senator Abler.
And so if, well, my comments are even different now, having adopted the previous amendment. But so if the individual has no rights that we can protect, could you at least give the individual some comfort if you're going to abort him or her? And this says, we discussed this in committee as one of the things we did get around to covering. One thing we didn't get to cover was the offering of, well, I'll just talk about the amendment first, then I'll offer a comment. So this amendment says that that you should include that if you're going to have abortions, there includes the optional provision of anesthesia to the unborn fetus at a time of development when it can experience pain. And Mr. President, it is well known that these little babies can experience pain somewhere around the 20th week. The neural tubes and all that form, some say as early as 16, but certainly 20, and certainly in the few weeks beyond that, these individuals can truly experience pain, and that is a consensus position. It's not anything that's even debatable anymore. And so even when they're doing their intrauterine surgeries, surgeons are now giving even 16-week and beyond babies anesthesia as they work on some of these amazing repairs to some defects that some of these yet unborn midterm babies have. And so I don't even think this should be controversial, but this just says, hello there, young woman, hello there, young couple, hello there, young, not young mom. Your baby can feel pain, and I realize you've made the decision to go ahead with the abortion, and that's your right, and you can have the right all the time you want now, according to this amendment and this bill. But would you like to at least comfort your little baby so that as he leaves the chance to live on earth, that he or she would not experience pain? Mr. President, I usually don't even get Novocaine when I go to the dentist. I don't like even the prick of it, and I'd just rather suffer through and get done. But when we give Novocaine to a person, they put this little goo on inside your gum, which tastes horrible, and then your whole outside gum goes numb. And then they put the needle in there, which is a pretty minor needle, to give us comfort. And so I don't know why people wouldn't want to provide something to that when you're going to be when they can feel pain. They're actually pretty good sized. And Mr. President, I did not bring some books along that I happen to have showing the fetal development. And at 20, 23, 25 weeks, they're really recognizable as like little people. And so to get them out is not a small task, and not a going to the dentist kind of a task. And so, but at least if you're going to take this person away, would you please offer them the chance to not experience pain? Thank you, Mr. President.
Additional discussion. Senator Rasmussen.
Thank you, Mr. President, and I speak in favor of the Abler amendment to the amendment. I think it's important for members, when deciding how to vote on this amendment, to understand some of the science around pain for unborn babies. The science would show that unborn babies at certain stages of development likely feel more pain than you or I would. And the reason for that is, Mr. President and members, is that oftentimes the part of the brain responsible for pain modulation isn't fully developed yet. And pain modulation is simply the experience of feeling pain initially, and then our brain modulating that pain so that we can actually flee whatever type of situation that we're in. And so, Mr. President, members, I would just beg of you to adopt this amendment. I think it is very reasonable, and given the science of what we know about unborn babies, when they can feel pain and how they experience pain, I believe that this is a common sense thing that all Minnesotans would agree to.
Seeing no more discussion, a roll call has been requested. Did you want to speak on this one? I'm sorry. Oh, roll call has been requested and roll call has been granted. Senator Grudenhagen. Senator McQuaid, I'm sorry, did you still want to speak, Senator McQuaid? Okay. Senator Gruenhagen.
Oh, thank you, Mr. President. Yeah, I would just rise in support of Senator Abler's amendment. You know, if anyone has doubts about this, they do unborn child fetal surgery, and they give the child anesthesia. Also, I think it was a little over a decade ago, a former member of NARAL, the National Abortion Rights, out of New York, he did a documentary called The Silent Scream. And in there, they showed as these unborn children were being dismembered, they actually screamed inside the mother's womb. So if you have any doubts about that, watch that documentary. That former member of NARAL did over 1,000 abortions till it finally dawned on his conscience that this was wrong. Then he did that documentary. So please support Senator Abler's amendment. Thank you, Mr. President.
Seeing no further discussion, the secretary take the roll. I was waiting.
No, Mr. President, I was just waiting to be called on. I'm not trying to be dilatory, but all right, thanks. So I appreciate the attention to this. I did want to ask Senator Morrison if she would yield just to describe how this is handled in the ordinary business of
Who'd you ask to yield, Senator?
Well, I asked if Senator Morrison will yield to answer a question about the practical application.
Senator Morrison will yield.
Thank
Senator
you.
Abler.
Well, thank you. And Senator Morrison, you know, we mentioned a little bit about ultrasounds. And so I know it's somewhere along the line on the right to know that you just talk about this topic. And I'm curious if you're aware if this even comes up in the day-to-day practice prior to an abortion, if the people are offered that or not. Thank you.
Senator Morrison, we are on the A65 amendment.
Thank you, Mr. President, and thank you, Senator Abler. You know, I would again say that we should not be mandating, legislating the practice of medicine in this chamber. There have been some comments about fetal pain and when that happens. Most rigorous studies have shown that that likely does not happen until much later in pregnancy when this is not an issue. But again, I would encourage a no vote on this amendment because we should not be legislating medical practice here.
Senator Abler.
Mr. President, I didn't bring 16 articles about fetal pain, but that's, I'm not going to debate the good doctor on the floor here about that. She does this, but my question was really about, do you make a point to offer women who are undergoing one of the most key experiences of their life the chance to make it a little better for the person who's going to be not ending the process with a chance to go meet them? And so I just wish that if members don't want to answer questions, then they shouldn't even yield. But I'm having a hard time getting my questions answered about when do human rights start, when does it become a person, and how does it even work in the day? And part of this is, Mr. President, is why I wanted this to go back to the committees so I could have the people in the audience tell us what they know about the day-to-day operations of Planned Parenthood and other places. That discussion is long gone, and I realize I can't make a motion to send it anywhere, which I'm not doing, but members, this is just humane, so please vote yes. Thank you.
I had a couple people over here. Senator Jasinski.
Thank you, Mr. President. I stand in support of Senator Abler's motion, and I'm going to go back and tell a little story. It goes way back. My son now is 24 years old, and when my wife was pregnant at the time, she was having a tough time during the last term of her pregnancy. He was so big, he was a big boy, and so we would take a headphone set and play Van Morrison, and we'd put it on my wife's womb or on their belly, and he would calm down just by listening to Van Morrison. And go ahead about 5 years ahead after he was born, we would play Van Morrison on the radio, and he would instantly calm. So these babies that are not born yet feel pain and they feel pleasure. So when you vote today, use your emotion. This is record-breaking things that are happening in Minnesota today. But think about that. My son, before he was born, was calmed by listening to Van Morrison. And then later in life, the same thing happened. Think about that when you're voting today. what that unborn baby feels, not only pain, but pleasure. And I really hope you take a second thought across the aisle about thinking and voting in favor of this today. Thank you, Mr. President.
Senator Weber.
Thank you, Mr. President. I had not intended to stand up in relationship to this debate right now, but I stand up in support of Senator Abler's amendment. It causes me great distress when I hear people on this floor that really try to skirt around a question, not wishing to admit what science has proven. These last few years, we have been lectured mercilessly about accepting science. And yet when it comes to science supporting a measure that they really don't want to hear or to have dealt with, then all of a sudden it's not nearly so important. I deal with issues in the committees that I have served in over the years, Mr. President, that talk about the humaneness of animal livestock raising in agriculture. We've heard about bills on the floor that talk about the inhumane manner in which maybe people are incarcerated or against capital punishment. And yet, when we get to the topic of killing a baby, let's not try to alleviate any pain that occurs to them. Mr. President, is that really where we as a society have come to? Is that really what we as a society can accept? Mr. President, I really don't believe it is. And I would hope that the members of this Senate sitting on this floor here today would look hard and deep within themselves to say that they can really justify voting no on this amendment.
Senator Pratt.
Thank you, Mr. President. Well, like Senator Weber, I wasn't planning to stand up on this amendment, but I think he and Senator Jasinski put it very well. This is about basic humanity. This is about compassion. To Senator Morrison's comments about not wanting to legislate procedures, I would draw her to the language in the amendment, including the optional provision. We're not mandating. We are not legislating that something happen. But we are providing in statute, as we've been told, this is to put belts and suspenders around what the Minnesota Supreme Court has determined, then we should be clear that we are standing up for basic human humanity. Mr. President, whether you believe that I believe these unborn children feel pain. But shouldn't it be an option then? An option to be able to prevent that pain from happening if this procedure were to go forward. We talk about the rights to make a decision. Shouldn't it be a right then to make a decision not to feel pain? This is about basic human humanity, and it is not a mandate. And members, I encourage you to vote yes.
Senator Coleman.
Thank you, Mr. President. I rise in support of this language. It reminds me of why I invested in a pair of noise-canceling AirPods. My sons were in the NICU for about a month, and the sound that these little babies would make when IVs would get changed, when blood had to be drawn, when veins would collapse and they'd have to attempt to perform a scalp IV, was something that would haunt me long after I went home for the evening. The procedures we are talking about today, Mr. President, go much further than a needle poke. This amendment is attempting to add some humanity to an inhumane procedure. And I would encourage our members to seek out the humanity within themselves and support it.
Senator May Quaid.
Thank you, Mr. President. Members, I'm going to urge a no vote, and I really just want to ground us in some reality. When you're pregnant and you have an appointment where you might find out some information, it sets off a cascade of appointments. You see a neonatologist, a fetal medicine specialist, non-fetal stress tests, so on and so forth. And at every point in your pregnancy, you are given all of the information and all of the options about what's before you. And so what this amendment does, including the optional provision of anesthesia, it implies that that's not already an option when it is. Because if we wanted to go through and say all of the optional things that are possible, we could do that. It would be a 1 million page bill. Every pregnancy is unique. And instead of using amendments to pretend like pregnancy, labor and delivery, and abortion care are something that they're not, is not useful. And so when Senator Morrison talks about not legislating medical practice, it's because this is part of pregnancy care already. Pregnant people are given information, they are given options, and if in this circumstance or their circumstances, this is something that is useful, it's something that is an option and available, of course they're talked about with that. So we don't need to add it in, but I believe that I believe that we should be grounded in that reality, that this medical care and that this pregnancy care that people receive for whatever unique circumstance they are in pregnancy, we don't need to legislate that from here. And we don't need to pretend like this isn't already happening when it is. So I urge a no vote so that we can continue forth with setting forth this fundamental right and not trying to legislate different specific medical procedures for people who are pregnant. Thank you.
Senator Nelson.
Thank you, Mr. President. I rise in support of the A65 amendment. And let me be clear, this is not pretending anything. We're talking about the common decency of offering a woman the ability to request anesthesia at the time of an abortion. And the science is clear. These unborn babies feel pain. There's some uncertainty about at which time that occurs in the pregnancy. But members, they feel pain. And I cannot understand why anyone would be against offering anesthesia in a case like this. And this idea that it's already in law, well, methinkest thou dost protest too much. If it's already in law, I would encourage you to not cast a no vote. And Mr. President, just yesterday, I think it was, we had the Crown Act on this floor. I voted for that, even though those rights were already protected in our human rights legislation. Members, I encourage a sensible, reasonable, humane yes vote on A65 and do not withhold anesthesia to these unborn children.
Still on the amendment to the amendment, the A65, Senator Johnson.
Thank you, Mr. President. So I'm again confused on what's happening here today. We were told that this bill needed to come forward to codify the law that's already in place, and Senator May Quaid just said that we don't need to codify this provision because it's currently offered in daily practice. Senator May Quaid, Mr. President, may I ask a question?
Senator, are you asking Senator May Quaid to yield for a question?
Yes, I am.
Will you yield? She will yield. Senator Johnson.
Thank you, Mr. President. And Senator May Quaid, could you please reconcile those two together for me? I'm just having a tough time doing that.
Senator May Quaid.
Thank you, Mr. President, and thank you, Senator Johnson, for the question. The difference between the things that I'm talking about, Mr. President, is that a fundamental right, which has been articulated by the Minnesota courts, that is enshrined in our Constitution, we need to put that in our statute. Because as was mentioned earlier, there's actually many laws that conflict with the fundamental right to make private health care decisions for yourself without the government interfering or trying to sway you one way or the other. In this particular case, we do not need to put into our law books the specific medical procedures that people may take during their pregnancy to suggest that without these laws, people don't have access to the full range of options in their pregnancy care throughout their pregnancy. Now, what I can tell you is that without enshrining the fundamental right to choose our own reproductive health care decisions, there are laws, and there could be laws, that would force people to make decisions about their health care that they don't choose, which is why it's so important that we pass House File, Senate File 1. But to answer Senator Johnson's question, the difference is to articulate and be clear and codify the fundamental right that has been articulated by the courts, but we do not have to articulate every single specific medical procedure that one could get during pregnancy, because that's just not necessary. That is how medical care works. Thank you.
Senator Johnson.
Thank you, Mr. President. And I'm starting to see a little bit of the confusion. I think Senator McQuaid may be under the confusion here that the Doe v. Gomez case enshrined a fundamental right for reproductive care, but the reality is that it established a fundamental right for pre-viability abortion. Now what we're dealing with today is everything from sterilization to family planning, to fertility services, to counseling regarding reproductive health care, maternity care, preconception care, contraception, extremely broad. Plus, this goes beyond viability. So perhaps there was a little confusion on the underlying bill. I hope this helped to clarify what's going on. So what we're doing today is not codifying existing law. What we are doing is expanding it. So what the amendment is doing for this right now is saying that, hey, if this is current practice, let's make sure we put that into law. But what we're doing with the underlying bill is greatly outexpanding, radically outexpanding what the case had to say.
Senator Rasmussen, you're on the list. Okay. Seeing no further, Senator Jaskowski, we are talking about the amendment to the amendment, which is A65.
Thank you, Mr. President. Mr. President, members, I support the A65 amendment to the amendment. Just listening to the debate, and you know, members, I saw a video the other day of what some of these late-term abortions look like. I'm sure many of you have seen it as well, Mr. President. We have practices that happen in this country where they rip the limbs off of the unborn baby in order to abort them. And some of the information I read suggests that babies can feel pain at a degree much greater than adults can. Unborn babies can. I was doing a little looking at our Department of Health website here and trying to look at what we do as adults for pain management. I found this huge study that was done in a report. Here are some of the things that they list in a table of things we do for the adults in the room. And I'm not a doctor. I don't know what all of these things are, and I think I can say them. Trigger point injections, joint injections, peripheral nerve injections. These are for the adults, men and women. Facet joint nerve blocks, epidural steroid injections, radio frequency ablations, regenerative adult autolog system cell therapy, celiac plexus blocks, cryoneuroablation, neuromodulation, spinal cord stimulator, intrathecal pain pumps, epidural adizolus, I might have butchered that one, vertebral augmentation, Mr. President.
Point of order.
For what purpose do you rise, Senator Klein?
Mr. President, it's been the tradition and custom of this body that we do not allow reading of documents in full on the Senate floor.
Members, I will not rule on that, but it is the custom and uses of this body that we do not usually read unless it's our notes, like our notes from something we've written as opposed to from someone else. So just with that gentle reminder, Senator Drazkowski.
Thank you, Mr. President. Apparently, Senator Klein, you became either annoyed or fatigued at listening to the list.
So, Senator, what we don't do is that we will not impugn another member and why they did something. That is deeply rooted in our Senate tradition. So with all due respect, I ask that you refrain from that, please.
Thank you, Mr. President. Well, apparently some members, Mr. President, are becoming fatigued at the list, and that was a point of order was drawn. Well, members, the effort behind that discussion, Mr. President, was to illustrate the extent to which we as adults in our health care, those of us who made it out alive, the extents to which we go at in order to control and prevent the realization of pain in our lives. And here we have a very sensible amendment by Senator Abler to provide the similar types of protection for babies that we know can feel pain, Mr. President. What are we doing? There shouldn't be any opposition to this. Mr. President, we have to adopt this amendment of Senator Abler's. It's common sense. This is where our culture is at, Mr. President. Our culture believes in this debate. This is the point in development where the biggest amount of our culture agrees on this subject. When the baby can feel pain and beyond. And we're going to, apparently, those opposed would purposefully keep this away from our healthcare people to be able to provide that for these, the youngest among us, the most defenseless among us, while we go ahead and do everything to provide the relief for the adults. So, Mr. President, I encourage adoption of the amendment. Members, I encourage you to think about the hypocrisy that exists in our policy here today between those defenseless people who are unborn who can feel pain immensely and what we do for adults who have successfully made it through birth. Thank you, Mr. President.
Senator Lucero.
Thank you, Mr. President. And I have such a grieved heart when I'm listening to this dialogue. When I hear the words being used to describe the most vulnerable among us in their mother's womb, and this language before us, the Abler Amendment that would seek to allow them to not feel the pain. Mr. President, I just appeal to the members for compassion and dignity in our culture, we do not tolerate such cruelty. And we have examples of that. In our United States Constitution, the 8th Amendment prohibits cruel and unusual punishment because we recognize that pain is not something that the state should inflict or permit on another person. We recognize that when it comes to animals. And I pulled up Minnesota statute here, 343.21, overworking or mistreating animals. And subdivision 1 speaks about torture. No person shall overdrive, overload, torture, cruelly beat, neglect, or unjustifiably injure, maim, mutilate, or kill any animal, or cruelly work any animal when it is unfit for labor, whether it belongs to that person or another person. Members, Mr. President, members, I just urge you to think about and have compassion on these people, that we don't inflict pain. So, Mr. President and members, I strongly urge you to support the Abler A65 amendment. Thank you.
See no further discussion. The secretary will take the roll. A roll call has been requested. A roll call was granted. Remember, we're on the amendment to the amendment, which is the A65. Senator Jasinski, those voting under Rule 40.7.
Thank you, Mr. President. Senator Miller votes aye.
Senator Miller votes aye. Senator Kunesh, those voting under Rule 40.7.
Senator Fa votes nay.
Senator Pa votes no. The secretary will close the roll. Seeing 33 ayes and 34 noes, the amendment to the amendment is not adopted. Senator Abler.
Thank you, Mr. President. And clearly, I think this amendment needs some more work, so I will move the A114.
Senator Abler offers the
A114, Mr. President.
A114, amendment to the amendment. The secretary will report the amendment.
Senator Abler moves to amend the A51 amendment to House File Number 1 as follows. This is the A114 amendment.
Senator Abler to the A114 amendment.
Thank you, Mr. President. And this is a simple amendment that says if if the practitioner doesn't inform a minor about the risks of sterilization, that there's a cause of civil action. The things they might want to warn the minor about would be cervical laceration, heavy bleeding, uterine perforation, infections, heavy bleeding requiring transfusions. The abortion might not work, and there's just many things that are negative about this procedure that could happen. And so I think that they maybe want to inform all that. There's been a history of, actually I got some of those points were not actually to this, I apologize, but the abuse of sterilization is a big deal. And they want to be having, make sure that there's, wait, I'm on the wrong thing here. So it's abortion or sterilization. Everything I said is correct. I apologize, Mr. President. So they want to make sure that they know this is not going to the dentist. The testimony has been, this is a simple matter, it's safer than childbirth, go ahead and do this, and all will be well. And there's some very serious side effects that can come from an abortion, including psychotic and emotional challenges. Some commit suicide. It is not casual, and members, I urge a yes vote on this to protect these minors, because they're going to be by themselves in many cases, and this is only fair. So, Mr. President, I'll request a roll call.
A roll call vote has been requested. A roll call vote has been granted. Any further discussions on the A14 amendment to the amendment? Senator McQuaid.
Thank you, Mr. President. And members, I really just wanted to, again, ground us in some reality. 95% plus of minors who access abortion care talk to a trusted adult before they do so. It's not always a parent. It usually is. Sometimes it's an aunt. I'm an auntie. I know I have nieces, nephews who come to me about important things. Sometimes it's a grandparent. But minors do talk to trusted adults before they access abortion care. And you know, to the 114 amendment, every medical procedure that people have in the state of Minnesota and across the country comes with informed consent. The good news for this body is that we don't have to tell doctors what to tell patients, and we should not, because with the exception of 3 of us in this room, we are not doctors, but based on medical standards, practices, what's appropriate for the patient, what's appropriate for the situation. Medical providers provide information to patients about the health care that they are accessing or might need to access or have experienced or whatever. And so, again, we're delving into this area where we are making assumptions about what abortion care is and is not, and what medical providers do and don't do. But I want to ground us in the reality that every medical procedure that Minnesotans have, regardless of their age, regardless of the kind of medical care they're getting, it comes with informed consent. And so we as a legislative body do not have to write into our laws what information doctors need to provide. They already do that, and it's actually appropriate for the patient and appropriate for the situation. So I'm going to encourage a no vote.
To the amendment to the amendment, the A14 Abler amendment. Is there anyone else before Senator Abler? Senator Rasmussen.
Thank you, Mr. President. I speak in favor of the Abler amendment. Mr. President, I just wanted to address a point that was brought up that was claiming that in every instance, medical professionals are already providing this information. And Mr. President, I had the opportunity to go to a panel discussion where there was a number of women who had abortions. And all 3 of them up on the panel who had talked about their experiences said that they were not told by the provider that they may experience emotional repercussions following the procedure, including depression, guilt, and distress. And because they were not provided with that information, they live today with damages. And so, Mr. President, I think this is a very common sense amendment. It also just applies, I believe, to minors. And especially, Mr. President, since the underlying bill does away with any notion of parental consent for minors, I think it's important for the minors to be provided with the information on the risks that these procedures could have for them.
Senator Weissenberg.
Thank you, Mr. President. I believe I heard a member mention something about doctors performing abortions. I do believe that if this law passes, you could be a mechanic in a garage and perform an abortion. So are mechanics inclined with the knowledge to inform people of how to safely perform an abortion and how to safely go through the healthcare practices? And even right now, I believe that abortion clinics, it's not always doctors performing abortions. So that seems to me would be an incorrect statement. Thank you, Mr. President.
Senator Klein? Okay, seeing no further discussion, roll call has been requested. Roll call granted. Senator Abler, I'm sorry. I did say that we were going to come back to you.
I was being polite.
I'm sorry.
You said anybody before Senator Abler, and so I just wanted to opine. I wasn't even going to comment again, but when Senator May Quaid said 95% are all good to go, 5% of 10,000 is 500. And a good number of those are actually quite young. And so I don't have the numbers in front of me. If you want to wait a minute, I'll pull them up. But let's say 10% of those are minors. That's 50 minors who are going to be cheering out in the hallway. And God bless the people. Mr. President, that was an amazing demonstration today of America and Minnesota. And people with deeply held beliefs, passion, feelings, everything were out there. And I wanted to go wander amongst them. And I felt no fear walking. I went down the one side and then down the other side where they were kind of divided in halvesies. And one side was less enthusiastic about me going there, but I did not feel any fear because that's the great system we have here. I think our discussion on the floor here has been extremely respectful, and Mr. President, you've actually facilitated that. But so some of those young people are out there going like, yeah, this is something we need to fight for, and I want my daughter to have this freedom, and I get that. And so in that enthusiasm of the moment, there's a few details you might want to know. And when we were out knocking on doors this last summer, it was like, oh, we need to protect this right to have this. And as Senator Duckworth said really eloquently in the beginning, I heard that a lot too. But what I didn't hear was that a 14-year-old girl, young woman, whatever, would have the freedom to go and, without telling anybody, actually the court had not ruled yet in some of these cases as we were knocking on the doors. It came after that. But in many cases, they didn't even know the extent of the current practice. But so they weren't thinking that a 14-year-old could go get an abortion after being coerced by her often 20-year-old boyfriend. And if you read the data, a lot of these first abortions and first sexual experiences are from young men who are of majority and they are minors. And it's really common. And I was as shocked as I've been preparing for some of these discussions of what I read and the pain. And so they don't want to tell their parents that it's like, let's just get it out of the way. And so it's not thought through, and there may be no adult in their life that they trust. And maybe it's one of their friends, like, yeah, I'll go with you. So you have two 14-year-old kids going down, and there's standards of practice, I know. But there is a whole bell curve of like amazing standard of practice where there's this sage doctor who goes like, let's talk about this. And have you thought about what's going on? And compared to the stampede that this bill seems to want to be creating, with no guardrails and no guarantee that this person will have that informed opportunity to decide truly. This just says, according to the doctors here, this says, please do what you've been doing. But I gotta believe there's some clinics and some clinicians who do not practice that. And in the rush, there was a reason the Right to Know had a 24-hour waiting period, was to slow it down. And the idea of the ultrasound viewing at that point was to, it's like, do you know what you're doing? It wasn't meant to be hurtful to the individuals. As a matter of fact, I know there was an effort, still is, to repeal it. Well, let's fix it. Let's make it work. Let's make sure that the information is medically accurate, but slow it down, would you please? What is the rush to make this life-changing decision, which is not without consequence? I read a list of some of the physical side effects, but Mr. President, I don't know what half of this body is reading when they're not noticing the psychological challenges and the lifelong depression that faces some of these women. Some of them came down to the Capitol on Sunday to say, please, please, I had an abortion. I regret it.
Senator Abler, I just want to bring you back to the A114. And I know that we're passionate about these, and members, I'm trying to be as thoughtful as possible, but you're not being as helpful when it comes to making sure we have sound debate and we stay to what you're asking us to do. So,
Good advice.
Senator Abler?
Good advice.
Just to the A14, please.
Yeah, but that's why you need this. So, and with that, members, I hope that this can go in the bill. At least it's a guardrail. And Mr. President, thanks for reining me in. I'm trying to stay focused, and it's just so deep to me. So, and so many people. Thanks a lot.
Senator Lucero.
Thank you, Mr. President. And as I was listening to the conversation from Senator May Quaid on consent and age, a couple things came to mind, and I'm wondering if Senator May Quaid would yield for a question.
Senator May Quaid, will you yield? She will yield. Senator Lucero.
Thank you, Mr. President, and thank you, Senator May Quaid. Senator May Quaid, do you recall or are you familiar that the Minnesota legislature in 2020 raised the age of consent to purchase tobacco from the age of 18 to 21?
Senator May Quaid.
Yes.
Senator Lucero.
Thank you, Mr. President. And if Senator May Quaid would yield for one more question.
Will you yield for another question? Yes, she will yield.
Thank you, Mr. President. And thank you, Senator May Quaid. As we're discussing this amendment to the amendment in front of us in regards to minors and consent, etc., as I had referenced in the previous amendment to the amendment, I'm concerned about minors and their inability to understand the full capacity of what they're doing and their decision making. And we have examples of that all across Minnesota statute. Just one of them, one of the more recent ones, was the tobacco. Now, raising from 18 to 21 isn't even minors. It's removing the ability for those that are aged 18, 19, and 20 from consenting. And so my question, Mr. President and Senator May Quaid, do you agree that there are topics, whether minors or even adults in the state of Minnesota, that we should not allow for them to make decisions on their own?
Senator May Quaid.
Thank you, Mr. President, and Senator Lucero for the question. Mr. President, what I believe is actually not important. What I can tell you is that the Minnesota legislature, in its infinite wisdom, has already said what minors can consent to, and I'll just read it for you. 144.343, minors can consent to medical, mental, and other health care services to treat pregnancy, venereal disease, alcohol, and other drug abuse, and the consent of no other person is required. And so we don't have to think about hypothetical scenarios. We already know that minors can access health care to treat pregnancy, including abortion care, without notifying or getting the consent of their parents. However, most of them do. Thank you.
Senator Lucero.
Thank you, Mr. President. I want to highlight how extreme this bill is. And voting against this amendment to the amendment would highlight how extreme and dangerous this bill is for the health of all Minnesotans. What Senator May Quaid just listed was a handful of very specific examples that don't include the very invasive, in some cases, non-reversible procedures. That list she just listed, drug and alcohol abuse, or counseling, or something to that effect. That is far different than what the Abler amendment to the amendment is seeking to do, such as sterilization. Those are worlds apart. And if we will not allow a minor to consent to get their ear pierced, if we won't allow an adult age 20 to purchase a pack of cigarettes, if we won't allow a 20-year-old to purchase a handgun, we won't allow a 17-year-old to vote, we won't allow a 16-year-old to enter into a legally binding contract. They cannot consent to these things because they don't understand the full gravity and potential unintended consequences. Moreover, Mr. President, Senator May Quaid referenced a 95%. That leaves 5%, and in a scenario, as Senator Abler cited, in 10,000, it'd be 500. But, Mr. President, I don't want just one minor to undergo a procedure that's irreversible and has lifelong consequences because they made a decision lacking the capacity of what that decision would mean. And so, members, Mr. President, members, we need to have common sense. Minnesotans expect us to have common sense. Minnesotans wanted us to be reasonable. And one more thing I would add. Minnesotans elected us. I have heard from a number of members, Mr. President, around the chamber that they can't make the decision, it's not up to them, it doesn't matter what their opinion is. Well, that is the exact opposite of what our role is. We have to create statute. We are the legislative branch, and it is our responsibility, it is our duty to make those decisions, such as the amendment to the amendment before us. And we have to define on who can consent and who can't. This is a dangerous bill, and this amendment to the amendment seeks to make this a little bit better, a little bit less extreme. And so, Mr. President, members, please vote green on the Abler amendment to the amendment.
Senator Jaskowski.
Thank you, Mr. President. Members, we have the ability here to prevent something. We have the ability to prevent in young people mental instability arising out of what I can only imagine can be a horrific experience. What the amendment says, members, is if a minor, 13 or 14 years old, a 13 or 14-year-old girl, gets an abortion or a sterilization, that we would require that they be afforded the information about how that could affect them, not only then, Mr. President, but for years to come. Maybe, Mr. President, for the rest of their lives. And we are going to deny them that information? This extreme approach by the majority, Mr. President, is harmful to our kids. I mean, we had an amendment in front of us to allow anesthesia, and it was another extreme decision by the majority to say no. We had an amendment to say at least provide the option for ultrasound and make that a fundamental freedom. And the Democrat majority, Mr. President, said no. Another extreme decision. Way off base with Minnesotans. I don't know a Minnesotan who would say that we shouldn't do those. I don't know one. I hear some arguing here today. I don't know any in my district that would say that. I'm meeting some today, Mr. President, that are saying no. And it's causing me to really not understand. Mr. President, I'm out of sync. Reality is out of sync with what we are hearing here today. It's out of sync with this bill, Mr. President. It's out of sync with the opposition to this very common sense amendment. We're going to be entertaining, Mr. President, legislation. I'm sure the Health and Human Services Committee is going to be entertaining legislation to figure out how to deal with the mental health crisis, as I've heard it said, that is plaguing our youth. Mr. President, half of those youth are women, young women, girls. And this amendment would help prevent negative impacts in mental health for girls. That is a type of responsibility, Mr. President, members, that we are sent here. That is our responsibility to prevent negative impacts in policy on people, including young girls. It is extreme to say no to this common sense amendment. It's a simple vote, members. Vote yes. Vote with the people of Minnesota that want common sense, that want to protect our young girls. Not the extreme discussion you're hearing from the Democrat majority here today, but from the people back home. Their sensibilities will guide you. They'll guide you in the direction that you signed up for when you ran for office. They'll guide you in the direction that they expect as they're watching you here today. They'll guide you in the direction that they expect when you go back home to sit down in the cafe to talk with them. Thank you, Mr. President.
Senator Gruenhagen.
Well, thank you, Mr. President. Yeah, and I rise to just encourage my members across the aisle to think seriously what the base bill does. This amendment to the amendment is completely reasonable. Basically the base bill strips away all traditional protection for minor young girls. And it leaves open the sexual exploitation of those girls by men. I really believe if you knew the statistics, it's a much higher percentage than what you imagine. How many young girls are exploited, then left to themselves and pushed into an abortion? Ladies, this bill, without any of these amendments, should be retitled The Sexual Exploitation and Isolation of Minor Girls. That's what it should be titled, because that's the message you're sending for your daughters and your young children. So members, and I especially have to address the ladies. Ladies, come to your senses. Think of what you're doing, okay? You're opening the door to the
Senator, I just want to make sure that we are speaking with the appropriate decorum and that you stay on this amendment to the amendment. I know that you've mentioned a couple of times the underlining bill, but we're not there. We're on the A114 amendment, if you will, my good friend.
Okay, thank you, Mr. President. I appreciate the correction. Without this amendment, think about what the underlying bill actually does. This amendment at least provides minimal protection for, and even civil action, for minor girls who have been exploited, okay? Let's not leave them completely defenseless. Let's add a few protections for them while they're being, if they're being sexually exploited. So members, especially ladies, think of what the door we're opening with this bill without any of these amendments like A114. Please vote in support of it if you care about your minor daughters and protecting them to some degree. Thank you, Mr. President.
Seeing no further discussions, the secretary take the roll. Senator Mitchell, did you want to speak or can we go and vote? All right. The secretary take the roll. Remember, members, we're on the amendment to the amendment, the A114. Senator Jasinski, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Miller votes aye.
Senator Miller votes aye. Senator Kunis, for those voting under Rule 40.7.
Senator Pa votes nay.
Senator Pa votes no. The secretary will close the roll. With there being 33 ayes and 34 noes, the amendment to the amendment is not adopted. We are now back on the A51 amendment as amended. Senator Abler.
Thank you, Mr. President. I have no more amendments to this amendment. I think it's really a bad amendment. I urge members to vote no. It was a really good amendment before, Mr. President. I kind of morphed along the way, and I appreciate the discussion on this amendment. But
And your amendment,
I urge members to
Senator
vote
Abler.
no. Thank you.
Which
no,
amendment?
I think that we can vote on this. I urge members to vote no.
I'm sorry? What are we doing? All right, seeing that there are no further
Mr. President?
discussion. Senator Dzik.
I ask for roll call.
Roll call requested, roll call granted. The secretary will take the roll. We are on the A51 amendment as amended. Senator Jasinski, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Miller votes no.
Senator Miller votes no. Senator Kunis, for those voting under 40.7.
Senator Pa votes no.
Senator Pa votes no. The secretary will close the roll. There being 0 yeas and 67 noes, the amendment is not adopted. We are now on House File 1. Senator Abler.
Thank you, Mr. President. I had no idea my advice would be taken so seriously by this body, so thank you for listening. Mr. President, I move the A120.
Senator Abler moves the A120 amendment. The secretary will report the amendment. Once we get it, just give us a little time just because
Mr. President,
there's a lot.
I have time, Mr. President.
Oh, you're okay. All right, the Secretary will report the A-120 amendment.
Senator Abler moves to amend House File Number 1 as follows, page 1, line 11. This is Amendment A-120.
Senator Abler.
Thank you, Mr. President. This actually mostly deletes the word sterilization. That's the point of this amendment, as a choice. And I don't know if you've been paying attention to the history of sterilization, and most of you probably have not, but maybe some of you have, and maybe we'll hear from what you think about that. But if there is a single abusive, next to abortion, which I think is right up there, but if there's another really bad thing that has happened to women across the world in the last several centuries, it has been forced sterilization, coerced sterilization, sterilization so you can't get health care without being sterilized, and particularly in people of low income and BIPOC, racial minorities, across the world. And giving this a fundamental right to this, I think is just opening up Pandora's box about the potential for abuse. And there's just, if you Google sterilization abuse, Mr. President, you will discover lots of abuse. And reading an article from what's their group? It's the National Women's Health Network. Curiously enough, they were criticizing NOW, and the National Organization of Women, for being soft on this, and they were able to get waiting periods. Mr. President, just so you know, in Minnesota, if you want to get sterilized currently, you have to wait 30 days to do that. Curious enough about the 24-hour waiting period for an abortion. Sterilization is so much more, well, they're both, I don't know why you want to have a 30-day for an abortion, but anyways, but it's a big deal, and they make people wait and really think about it. And I don't think we should make that a fundamental right, Mr. President. I don't want to leave it lying around for someone to be abused, particularly in this bill, given the current state of law in Minnesota. Now, under the previous regime of laws that we had, that's not the right word, but in the previous array of laws we had before they were struck down last summer, a person seeking this kind of service as a minor would have to have their parents be somehow involved. That is not the case now, Mr. President. And if you listen to Senator Gruenhagen talk about his concerns about trafficking and abuse, it does happen, Mr. President. It particularly happens in runaways and in young girls, and the very common runaway trafficking person is 14 years old. And so, if it's necessary, I can remind you about some of the international abuses, but they are many. And they start in our own South with just innumerous things. And so you probably already believe it's a dangerous procedure. I think it should not be a fundamental right. It could still be perhaps under the not limited to, but I wanted to take the not limited to away so that it doesn't include that at all. So, Mr. President, I ask for a roll call on this very important amendment. And I urge people to, since you're kind of listening to me, vote yes. Thank you.
Roll call vote has been requested. Roll call vote has been granted. Senator Green.
Thank you, Mr. President. I stand in support of this amendment. I was going to speak on this later, but now that the amendment's here, I will bring it up now. And I will bring it up again later because this is very important to me. This is personal to me. As I was reading through this law, this House File 1, and looking at again, how extreme this is, and it talks about sterilization, and it talks about every individual, doesn't say boy or girl, doesn't say man or woman, it says every individual. There's no age limit, and I've heard the number thrown out here, age 14, but this doesn't stop at 14. This could be 13, 12, this could be whatever. It could be both male and female, and granting the fundamental right. Therefore, it can't be taken away if this law passes. And I wonder, and I'm not going to ask questions, but just a rhetorical question, how many of us that have children, that have raised children to adulthood, would believe that a 11, 12, even 15-year-old child has the ability to make these decisions, and yet here we are. And it's just so extreme. The words don't even want to come out of my mouth when I think about this. And as I was reading this, there's some history behind this. And I intend to talk about it now, and I intend to talk about it later, because back in this whole sterilization, this eugenics program started back in the early 1900s. And I don't know, as a member of the White Earth Nation, I don't know any family that wasn't at one time affected by this, including my own, where young women would, at the time they called it get into trouble, they'd be shipped off somewhere, and they would be sterilized. And it didn't always have to happen if they got pregnant. And this has been going on, and it was back and forth in the courts. And by the 1970s, they actually passed what I believe is the preview to this law, this horrible, extreme law. And in 1970, it was called Family Planning Services Population Research Act of 1970. And when this thing was passed, they estimate that maybe 25%, all the way up to 50% perhaps, of Native American girls were sterilized. Some of them did go in for abortions, and that's true, but most of them, that's not always the case. The extreme cases were two 15-year-old girls who went in for tonsillectomy into the Indian Health Services, and because of this act, they were sterilized, and they didn't even know it. And even in this law that was passed in 1970, just like the law we see before us today, you had to have approval. But you didn't always get approval. It was happening anyway, or they were coerced, or they were lied to. In one case, a 20-year-old woman went in. She was having some problems with drug and alcohol abuse, and they performed a hysterectomy on her, and they told her that if she agreed to do that, they could be reversed later. 6 years later, she was married and decided to start a family, and she went in to get it reversed, and they told her, no, you can't. She was lied to. These kind of laws devastate people for years to come.
Members, I want to gently remind us, I know that this is a very tough and emotional issue. It is the tradition of this body that we don't hit on desk and we don't yell. We speak with clarity and with the required emotion. So I'm not suggesting that it's not an emotional topic, and this is something that's near and dear to you. But I ask the members, all members, not just one, to refrain from hitting and yelling in this chamber. Senator Green.
Thank you, Mr. President. And it is very emotional to me. And I won't go into my own family stories, because I don't think it's proper to tell personal stories unless I talk to the people first. But this practice has gone back and forth. This practice in 1970, by 1977, it was supposedly ended, but it really was not. And this kind of stuff still happens today. And now in Minnesota, we're going to codify this into our law once again. And when you look back through history, and we look at all kinds of things that happened in our history, and we judge those people, they don't care, they're dead. But here we are, and we're making the exact same decisions that they made. And how will history judge us as this moves forward? This amendment is a good amendment. These words should never be in here. This bill should never be in front of us, but these words should certainly not be in here. And to think that we can do this without imposing any kind of a limitation on anything. I just trying to imagine a young girl, 12, 13 years old, going in because she's having problems, and maybe they perform an abortion, and in a late-term abortion, and that young baby is pulled out, and she has to watch it die. If it doesn't die, according to this law, it can be laid on a table and die. This is wrong. I'm going to end there. There's much more to talk about this, but I urge a yes vote on the Abler Amendment.
Senator Dibble, to the A120 amendment.
Thank you, Mr. President and members. I'll be very brief. I wanted to respond to Senator Green's arguments in favor of the Abler Amendment. Everything Senator Green talked about is terrible and should never happen in people's lives. And thankfully, the bill brought to us by Senator McEwen addresses that very matter. And so, members, I want to draw your attention to lines 1.14 to 1.16, where it says quite clearly, reproductive freedom. Every individual has a fundamental right to make autonomous decisions about the individual's own reproductive health, including the fundamental right to use or refuse reproductive health care. So once again, I commend Senator McEwen for bringing an important bill in front of us that affirms people's right to autonomy, to self-determination, to make decisions about fundamental things in their own private life, so that everything that Senator Green just described will not happen to those people. Thank you, Mr. President.
We are on the A120 amendment. Seeing no discussions, I'm missing one. Senator Kunesh.
Thank you, Mr. President. The history that Senator Green described is absolutely true. We know that our Native communities have been plagued by violence and attempts to exterminate us. That is true, absolutely true. And as we have gone through this discussion, we hear about, Senator Gruenhagen has brought up many times about these young girls who are easy prey to traffickers and violence and all of those sort of things. But I think we have to stop and think, as we have all of these male members standing up trying to manage women or reproductive freedoms for individuals, who are those perpetrators? And so I remember when I was working on the Missing and Murdered Indigenous Women's Task Force, and we had a hearing, and we were hearing horrific things about the violence against our Native women. And there was a county attorney from Stearns County there. And the question was posed to her, like, who is this? Who does this? And her response was, white men in their mid-30s with disposable income, a wife and children. These are the people that are preying on us. These are the people, these are the things that we should be creating laws around, not women and their reproductive rights. I want to ask Senator Abler a question, if he would allow.
Senator Abler, will you yield? He will yield. Senator Kunesh.
So my question to Senator Abler, if we were to strike the word sterilization from here, would that mean that women who have difficult pregnancies and their doctor, after discussing with them very thoroughly the repercussions, the consequences, would that mean that that woman would not be able to become sterilized? She could have her tubes tied if she so choose after going through difficult pregnancies.
Senator Abler, to the question. We're on the A120 amendment.
Yeah, and I appreciate the question. And so if I understand what you're saying is a person goes in and wants to have a sterilization, an ordinary days of their health care that they go get. This doesn't prohibit that at all. But I want to I'll look at you. I'm sorry. Mr. President, I wish we could look at each other. I think it would make the dialogue better. I understand the Senate rule, and you're really good to look at, and you're always so attentive, at least most of the time. So I appreciate that.
Well, Senator, thank you for the compliment.
Yeah.
Continue to speak through me.
I will
Thank
continue
you.
to speak to you, and it bounces off, and I got it. But here's the deal. This is not a bill to outlaw any procedure. This is a bill to enshrine in statute the fundamental right to an array of services that are not currently fundamental rights. And so taking the word sterilization out of this would merely take away the fundamental right of a 14-year-old to go on her own to a doctor and say that that she wants to get a sterilization. That's all it would take away, the fundamental right part. If she still wants to go under current law, she can still go. But my concern is about the abuse, and this is happening on the border today, Mr. President. And so I'll leave. So it would not change her one little bit, Senator Kunish.
Senator Kunish.
Yes, I think it would have definitely repercussions, because if the word sterilization were to be removed, it would be ambiguous. It would not give that woman the right to make that choice. And so I would suggest to all of the members to vote no on this amendment, because once again, it is an amendment by a non-female trying to regulate the right of each one of us to choose our own reproductive rights.
Senator Howell. Excuse me. Yes, Senator Howell. You're on my list right here.
Thank you, Mr. President. I stand here as a man who has been elected by the people of my district, and to suggest that because I'm a male, I cannot represent the women of my district upsets me. That would nullify a lot of discussion. Mr. President, you should not allow that type of discussion in this chamber. To say that an elected member of this body cannot represent the opposite sex of their district. And that's what's being suggested by the senator today, twice in this discussion. Because the majority, the tens of thousands, I shouldn't say tens of thousands, but the thousands of emails that I have received and phone calls were mainly from the women of my district. And I plan to stand here today and represent those women. Because if you tell me that I cannot stand here, Mr. President, and voice their concerns, you have silenced all those women. And that is inappropriate in this chamber, Mr. President. Thank you.
All right, Senator Abler. Oh, Senator Dornick.
Thank you, Mr. President. So sterilization for underage girls is just very extreme. It really bothers me as a father of 8 daughters. I just can't believe that a parent would stand for that. But I want to talk too a little bit about the history of sterilization in this country, just that forced sterilization, because there is a history. In 1920s, there was a case called Buck versus Bell, and Carrie Buck was accused of being unfit, feeble-minded, and not fit to have children. So they went all the way to the Supreme Court. This was in Virginia. They went all the way to the Supreme Court. And the Supreme Court got it wrong, like they sometimes do. And the vote was 8-1. And so when I was reading this, I like to see who the one is, because that's the man or the woman that will stand against their peers, against their colleagues, to do what's right. And that's the kind of man I want to be and ascribe to. Interesting enough, that man was from Minnesota. Pierce Butler stood against 8 of his colleagues and said, "This is wrong." And he was right. So I stand here saying this is wrong to allow this option, this health freedom that it's so called, for young girls. It could be as young as 10, 11, 12. So I stand in support of the Abler amendment. Thank you, Mr. President.
I have to go according to my list, and I'll make sure I get each person. Senator Lucero.
Thank you, Mr. President. And as I was listening to the conversation from Senator Kunesh, I had some clarifying thoughts that I need as we are considering this amendment to the amendment. And so based on that, Mr. President, to help myself and members of the body bring clarity to this amendment to the amendment, I'm wondering if the chief author of the underlying bill would yield for a series of questions.
So, Senator Lucero, you're asking for the chief author of the amendment or the chief author of the bill?
The underlying bill, Mr. President.
We are on the amendment, so all your questions must be directed to what's before the body. What's before the body is the A20 amendment to the amendment.
Okay, Mr. President, point of parliamentary inquiry. So I prefaced my requesting the chief author of the underlying bill to yield for a question with some remarks. You were distracted, and so you may not have heard. Based on the comments from Senator Kunesh that I heard, it brought up some information to help me in my consideration of the amendment to the amendment that I need clarified on the section of the underlying bill that is seeking to be amended that I need answered, and that can only happen by the chief author of the underlying bill. So based on that, that's the reason why I asked for the chief author to yield for a series of questions. But then you said some remarks that I don't understand. Are you saying that I can't ask her to yield?
Senator, what I'm saying is, if you're going to, and I did seek to get some clarification from my read of it, if you're going to ask the chief author of the bill to yield, any and all your questions must really pertain and connect to the amendment which is before the body. So if I'm getting the assurances that that is what your inquiry is going to be and connect to that, because there's a nexus to the amendment, then we would so allow it if she would yield for a question. Are you asking her to yield?
I am asking her, yes.
Will you yield? She will yield. Senator Lucero.
Thank you, Mr. President, and I appreciate those remarks, and that's why it was in my attempt, and again, I understand that you were distracted there. It was my attempt to preface that my questions for the chief author are pertaining to the conversation from Senator Kunesh and are related to the amendment that's before us. So I need clarification. That was the reason why. So again, I appreciate this dialogue. So my first question is, based on the conversation I heard with Kunesh, she had made some references that this is a bill on women, and she had actually asked Senator Abler to yield in pertaining to the amendment to the amendment. And then her remarks were focused on women. So my first question for the chief author of the bill is the underlying bill pertaining to just women, or is this pertaining to both men and women?
Are you asking that of Senator McEwen?
The member I asked to yield, correct.
Yeah, Senator McEwen. The question is whether this is for men and women. I believe that's the question. Senator McEwen.
Thank you, Mr. President, and thank you, Senator Lucero. I just need a little bit of clarification. Is the question whether the entire bill refers just to women?
Senator Lucero.
Thank you, Mr. President, and I'm very happy to clarify. In the conversation that Senator Kunesh asked Senator Abler to yield, she had asked the question, would removing the word sterilization and then she went on and suggested women. My question for the underlying bill author is this underlying bill, will it pertain to just women, and I'm using the word women, of those age 18 and above? Would it also pertain to adult women in addition to adult men?
Senator McEwen.
Thank you, Mr. President. In answer to that question, I I must confess that I had to run out to take a restroom break and did not hear the interchange, so I am missing some of the context. But the bill refers to individuals. Thank you.
Senator Lucero.
And then just one follow-up, if she would yield again.
Will you continue to yield? She will yield.
Thank you, Mr. President. And a further point of clarification, does your bill, in the use of the word individual as it is in the bill, will that apply to girls, those under the age of 18, and boys under the age of 18?
Senator McEwen.
Thank you, Mr. President. Thank you, Senator Lucero. Again, the PRO Act does not change any laws about minors or abortion health care and the relationship right now that exists to access for minors for abortion care. As we've already discussed, minors can already consent to pregnancy care, abortion care, venereal disease treatment, mental health services. Again, the PRO Act codifies what is currently Minnesota law. That is, that it provides that we have a fundamental right to make autonomous decisions about our own health care, and it does refer to individuals. Thank you.
Senator Lucero.
Thank you, Mr. President. So that clarifies for the body that this bill is going to have an impact men, women, girls, and boys. Males and females, regardless of age. Second, this extreme bill erodes, contrary to what was just heard, that it doesn't change law. In fact, actually, if she would yield, I wasn't my intention, but based on her most recent answer, would the underlying chief author of the bill yield for another question?
You're asking for the chief author to yield for another question. Will you yield? She will yield. Senator Lucero.
Thank you, Mr. President, and thank you, Senator. You just listed several things in the context that law wouldn't be changed. Under present law, does a minor boy or a minor girl have the ability to get themselves sterilized at the age of 10?
Senator McEwen.
Thank you, Mr. President. And thank you, Senator Lucero. I'm going to perhaps defer to our medical doctors here in the room to discuss what the medical practice might be, but my understanding, again, well, not my understanding, but what the PRO Act does is codify rights that we enjoy now. It doesn't change anything. It doesn't change anything in regard to the questions that are being asked about minors either. So the PRO Act is for all Minnesotans, and I guess I will just leave it if we know that there are medical standards of practice that doctors and healthcare providers have, that they follow, that they have to abide by, and I guess I'm not a doctor, so I don't exactly know how that works, but thank you, Mr. President.
Senator Lucero.
Thank you, Mr. President. Would she yield? Would Senator McEwen yield again?
Will you yield? She will yield. Senator Lucero.
Thank you, Mr. President. And perhaps I wasn't clear. I'm not asking a medical question. I'm not asking about medical procedures. I'm not asking about medical guidance. I'm not asking about a doctor's opinion. I am asking, under Minnesota law, does a minor, boy or girl, preteen, have the right to sterilize themselves?
Senator McEwen, and I would like to remind the body, we need to tighten up the focus of our questions to make sure it's about the amendment that is before us. But Senator
Mr. President, actually, before you give it to her, I would actually, on that note, my question about sterilization and present law is directly 100% related to the amendment before us, which is dealing with sterilization. I cannot become any more focused. Thank you, Mr. President.
Senator McEwen.
Thank you, Mr. President. Respectfully, this is just simply not how medical care works, reproductive medical care, and it's just not a thing. So that's my answer. Thank you.
Senator Lucero.
Thank you, Mr. President. I'm not getting an answer. My question is, as I'm considering this amendment to the amendment on sterilization, and Senator Abler's attempt to remove the word sterilization, I want to know if minors presently have that ability under Minnesota law without any parental consent or notification. And I need to know that because this bill would allow that. And I've heard it repeated that this doesn't change law. So I need to know if it's going to change law as I'm considering the question before us. So on that note, Mr. President, because the chief author said she doesn't know, effectively, those may not have been her exact words, but that's effectively what it's leading to, I guess I'll have to ask some other members. Would Senator Dietzich yield for a question?
Senator, we are not going to have a time where we're wasting time. Now, I've been very patient, but we're not going to go through every member of the body in order to try to answer a question that you also have Senate counsel to go through, and you have researchers on your side in order to do. Now, I'm being as patient as possible, but I would not, my wish is not to waste the body's time, okay, as it pertains to that question.
Mr.
But
President?
we will go to a doctor who is in the room. Senator,
Are you taking the floor away from me, just to make sure I understand?
Okay, nope, you're right. Is there someone else that you would like? You said that you need to understand the question, and I'm trying to help you get it answered.
I'm trying to, a doctor will not be able to, in my opinion, Mr. President, a doctor isn't going to be able to answer that. I need somebody more familiar with Minnesota statute. It was my presumption that the chief author of the bill would understand the ramifications of her bill and how it impacts present law. I asked 3 times, wasn't able to get an answer. I suspect I wasn't able to get an answer because this does change current law. And in doing so, this is very extreme. This bill before us is extreme. That's why this amendment before us, amendment to the amendment, is seeking to change that. This bill puts us far outside the mainstream of the rest of the country and puts us on par with radical countries around the world. The Abler amendment to the amendment is seeking to put some controls, Mr. President. This bill, this radical, extreme...
Mr. President, point of order.
For what purpose, Senator Friends, do you rise?
Thank you, Mr. President. I would ask you, Mr. President, to remind members that we are on the amendment and to keep remarks confined to the amendment so that we can move the business of the Senate along. Thank you, Mr. President.
Members, just another friendly reminder.
Mr. President, point of order.
Senator Pratt.
Thank
For
you,
what
Mr.
purpose do you rise?
Thank you, Mr. President. Point of order in response to Senator Frentz, and as well as the proceedings today. Before Senator Lucero began to speak, and he asked the chief author of the underlying bill to
Senator Pratt, what is
yield.
your point of order?
My point of order, sir, is you chastised Senator Lucero about staying to the amendment, and now we are continuing to take the floor away from him. The point of second Mr. reading
President,
is
point
to
of
debate.
order.
Excuse me. I'm on my point of order. sir.
That's not a point of order, Senator Pratt.
Members.
It's an argument with the President, which is not in order.
Members.
Mr. President, I think I
the
have
reason why I'm pausing is because I'd like for you to take a deep breath. Take a deep breath. I realize that this is a very difficult topic. Senator Pratt and the others, I'm going to just gently remind you, and then I'm going to ask you to sit down, okay? Because we want to give him a chance to finish what he's saying as long as it is to the amendment. So I did not chastise, just so that we're clear on our words, because words mean something, especially to us lawyers that are in the room. What I've reminded everyone throughout the day is to make sure any discussion is to the amendment. And in fact, sometimes when people were talking, And if they were going afoot, I wouldn't do it on the mic. I simply hold up the sheet of paper that they've seen me do in order to make sure that their comments got back to the A20 or whatever amendment that we were on. And now, so if you have a point of order that is rooted in a rule, I'll be happy to hear it. If I don't, then I'm going to go back to and not rule on the point of order, but allow the individual to finish. Now, Senator Lucero, if you would keep your comments so kindly, I gave you some latitude because you told me that the chief author of the bill needed to ask some questions that you felt were important and had a nexus to the 120 amendment. And so the only thing I said is I was not going to let you start questioning every person in the body because there was some information that you wanted that you also had access to. So with that being said, you may continue, but with those parameters, if you would be so kind.
Thank you, Mr. President.
Senator Lucero.
Thank you, Mr. President. And the reason Senator Dietzig was among the members I'd asked to yield after Senator McEwen was because she's a co-author on the bill. And perhaps because Senator McEwen was unable to answer my question related to sterilization, Senator Dietzig would have been able to answer that. That was the reason. At this point, I'm still seeking to get that answer, so what I would like to do is ask Senator Limmer to yield if he's willing.
Senator Limmer, are you willing to yield? Senator Limmer will yield. Is Senator Limmer a co-author?
Senator Limmer is not a co-author on the bill.
All right. Senator Limmer.
What Senator Limmer is somebody with long-standing historical institutional knowledge as a member of the Public Safety Committee.
Absolutely.
And he may have the answer. I don't know. So my question, Mr. President, for Senator Limmer is, does he know, and he may not know, but does he know if minors can get sterilized right now without any parental involvement, consent, or notification?
Senator Limmer, to the question.
Thank you, Mr. President. Senator Lucero, I'm not an expert on this, but I have been listening to the discussion. I think what you're trying to get an answer to is, what is the difference between the current practice of those who seek sterilization versus what Senator McEwen and the new standard would be if this bill passed? I think that's the question, and I think Senator McEwen, being the chief author of the bill, should know that difference.
Senator Lucero.
Thank you, Mr. President. That is exactly the question I'm trying to ask, and I understand your position, as I know Senator Gruenhagen had earlier mentioned. He doesn't envy the position that you're in, and I appreciate your patience with this conversation. And I assure you, it is not my intention to delay. I'm not trying to drag the feed. That's honestly not what I'm doing. I wholeheartedly, I only got up to rise as a result of the conversation I heard from Senator Kunesh. It's the only reason I got up, because I heard it was related. She only used the word women, and then the conversation on sterilization. That's the reason why, because I heard that this doesn't change law, and it's my understanding that it does. That this bill does change the law. It does change Minnesota practices. It will be expansive, and it'll eliminate parental involvement in their minor children's health care decisions with no age limits, as we defined in the very first hour of this bill. I asked the question, is there any age parameters? And there aren't any. And so this extreme bill puts us on par with countries around the world such as China and North Korea. This amendment to the amendment, this amendment, it's not an amendment to the amendment, this amendment seeks to add a little bit of control, put some guardrails, and to protect our minor children from sterilization. We do not want minor children to be sterilized without parental involvement. So with that, Mr. President and members, please vote for this amendment to the Democrat extreme bill. Thank you.
Senator McQuaid.
Thank you, Mr. President. Maybe I should get a t-shirt that says this: I'm going to reground us in reality. The first piece that I want to distinguish is the difference between government-forced sterilization, which is akin to government-forced birth, which is the horrific history we've been talking about of sterilization in this country. It happened to indigenous people, black people, Latinas, and it's horrific. The PRO Act establishes each individual's right to ensure that they can make that decision or not, separating us from countries like North Korea and China that use the government to force people to have children or force people to have abortions. This allows Minnesotans to retain that right. And I really want to clear up any confusion. The thing that stands between 10-year-old boys seeking sterilization or not is not that we haven't enshrined the fundamental right to autonomous healthcare decisions. It's not a thing that happens. There are no 10-year-old boys sitting around with their Pokemon cards being like, you know what, that YouTube video was funny, but tomorrow I'm going to go get sterilized. That's just not a thing that happens. Something that does happen are adult women and people with uteruses who decide that they don't want children or more children, and they would like to get sterilized, and they're condescended to, saying, well, what if you change your mind? What if you meet somebody who wants children, this hypothetical person you're not even with that might want children, and won't you regret it? People have a right to make decisions about their own bodies. And something else that happens to young people is sometimes they get sick. And the health care that they need, whether it's radiation or chemotherapy, might have the secondary effect of causing them to be sterilized. And there are times when sometimes that health care isn't considered for those young people because it could cause that, even if that's the health care that will save them. And so I don't want us to live in a place that doesn't exist. I want us to live in reality where we do have a history of the government forcing people to get sterilized. And we have a not too far away history of some states forcing people to give birth. That is not going to be Minnesota. In Minnesota, we will not use the government to control your reproductive health care decisions based on the beliefs of the people in this chamber. In Minnesota, every Minnesotan gets to make decisions about the health care for their body, for their reproductive health care decisions, without the input of the members of this chamber. And we won't fearmonger about things that don't happen and aren't real in order to get rid of these fundamental rights. And so I would urge a no vote on this amendment and to just stay right here in this reality. Thank you.
Senator Wiesenberg, you're on the list.
Thank you, Mr. President. I would assume that 10-year-old boys sitting around playing Pokemon aren't thinking about getting sterilized, nor 10-year-old girls sitting around playing Pokemon aren't thinking about getting sterilized. So I see no reason we can't make an amendment to have no sterilization in these kids. If that is a thing that doesn't happen, there should be no reason we couldn't have that amendment. That is not speaking to this amendment, but I believe that may be one coming up soon. Thank you very much.
Senator Mitchell.
Thank you, Mr. President. I am strongly against anything that curtails the rights of minors, and I will tell you why. I've heard a lot of people here today suddenly talking about trafficking and underage kids and all these things to make political points. People who I have never actually heard express interest for these at-risk groups at any other time. Some of you may know I'm a foster parent. I have served 6 children through respite and full-time care since 2018. Prior to that, I spent several years as a court-appointed special advocate. I've done other work at a domestic women's shelter, which included children there, at a homeless shelter, specifically working with the children there, I have worked with some of these at-risk kids. I keep hearing people say, well, they just need to ask their parents. A lot of children do not have that option. Their parents are not around, their parents are not available, their parents are not stable. There are parents that would let their minor child die of an ectopic pregnancy, which, by the way, the outcome is always death because of the parents' medical beliefs that the child didn't share. There are parents that might have a child who has a cancer or whatever else who would need sterilization, who again might let their child die or risk death because of their belief. And that's if that at-risk child can even find a parent or a guardian or someone else to sign off. Children are raped at every age, to include infants. A girl I mentored bounced through 6 different foster families while going back and forth to her original family where her father continued to molest her every single time. And now you're asking a girl like that, if she happened to get pregnant, to have to go to the same parent and get permission to get medical care? Yes, parents should absolutely be a soft place for children to land. Yes, it would be wonderful if every child was able to trust their parent and know that if they went to a parent with a pregnancy, they weren't going to get beaten within an inch of their life or something worse. But the reality is those things happen. And so I trust that those children that are in those traumatic situations will find the best person for them to help them through that situation. But unfortunately, the sad fact is, parents and guardians do not always look out for the best interest of their children. And I have seen it my entire adult life again and again, in and out of the court system and with the abused and neglected children I serve. So I strongly am against anything that would take away the right of someone at any age to make critical medical decisions. And I implore people who don't actually have an interest in these children to quit using them as political pawns.
I'm going to my list, members. Just want to make sure that I'm being fair here. Senator Bowden. You are on the list. Okay. Senator Grudenhagen. And I have you on the list, Senator Wiesenberg.
Okay, thank you, Mr. President. And I rise in support of this amendment. I think it's a small step to reducing the radical extremist of this bill. You know, Senator Kunish invoked my name and then talked about how certain men are sexually exploiting women. And I would just add, Senator Kunish, that there's really 3 primary things that I've come to believe that promote the exploitation, sexual exploitation of women. One is abortion. It sends a bad message to men that they can kill the consequence of the sexual exploitation of women. Second is pornography. Pornography objectifies women. It sends the wrong, absolute wrong message to men. And yet we live in a sex-saturated society. You can't hardly turn the TV on or listen to almost anything without women being objectified. So if you want to stop the exploitation, a good place to start is by putting strict limits on abortion and fighting pornography. Remember, members, it was 7 men, not 7 women, that legalized Roe v. Wade.
Point of order.
So what purpose do you stand?
Under Rule 36, Mr. President, that we should address the subject at hand, the amendment before us.
I'm going to caution the body, Senator, senators, we have to always make sure that we are addressing the matter at hand. I know that this is a very emotional topic, but we can't keep referring back just to our own narrative. We got to just deal with and debate the issue that is before us. That's the only thing I'm asking. Okay, Senator? Senator Grutenhagen.
Well, thank you, Mr. President, and appreciate the advice. Again, you've got a difficult job, okay? But, you know, there's a third thing to it in education, but I won't discuss that. That leads to the sexual exploitation of women. But this amendment, members, we stand up and say, well, it's optional now. Well, I've worked with government long enough to know that what is optional today is mandatory tomorrow. So we are on a path to eugenics, which was practiced in the U.S. in the late 1907 to 1930, even into the 70s. We had testimony about that. So don't think in a minute that there won't be lawsuits or action taken to make this mandatory. And that's what you have to understand. And one of the reasons this amendment is so important to add to this extremist bill. It's at least a small step in the right direction. Thank you, Mr. President and members.
Senator Riesenberg, I'm sorry.
That's all right. Thank you, Mr. President. I just wanted to speak to something I heard another member say about ectopic pregnancies. Ectopic pregnancies aren't abortion, that would be health care. So it's not an abortion. You'll be able to continue to have your health care procedures. And also I have 3 children, so I'm speaking for my children, and I believe everybody else here that has children is speaking for their children. We're not using anybody's pawns. We're just concerned about our kids and all kids, and we want to do what's best for everybody. Thank you very much.
Senator Limmer.
Thank you, Mr. President. Mr. President, and namely Senator Lucero, I was thinking about your question regarding this amendment. As I was listening to the conversation and thinking about it a little bit more, I can see why you would raise the question, because the reference of abortion and the practice in Minnesota is that a parent is denied information if their underage daughter wishes to get an abortion. The question is not specific in the legislation before us, but I can only assume, since that's the practice in Minnesota regarding abortion, I can only assume that that will be the practice regarding sterilization, unless the author can tell me differently and point at it in her legislation. I can only assume that a parent will not be told when their, let's say, a teenage daughter, underage daughter, or boy seeks sterilization without their knowledge. So I think the question should be to the chief author, is my summation incorrect? And if it is, could you point to it in the bill? I'll ask Senator McEwen to yield to that question.
Senator McEwen, are you willing to yield? You got to talk into the mic.
Thank you, Mr. President. I will yield, but I need the question to be asked again. A lot was said there. Thank
Members, remember that we talk in mics. Please don't yell in the chambers. Senator Limmer, if you're willing to re-ask the question, please.
Mr. President, I don't yell too much.
I'm sorry?
I don't yell too much, Mr. President.
Yeah.
I may speak softly, and you'll have to ask me to repeat my question, as you just did. Senator McEwen, Senator Lucero and I have been having a rather public discussion here in the Senate chamber. I don't know if you've been listening to it. I think what he was really trying to ask of you is what will be the practice of the state of Minnesota in the event that a young person, someone under or a minor, wants to have a sterilization. Will they need to inform their parents? As you may know, the practice in this state, if a minor wants an abortion, they do not need to inform their parents of that abortion, and they can get it independent of parental advice. So the question comes up, and I think it's a reasonable one. In the event that a minor wants sterilization, are they required to inform their parent, or in your bill, will they be treated the same way that a minor can avoid telling their parent regarding abortion?
Senator McEwen.
Thank you, Mr. President. Thank you, Senator, for the clarification on the question. As I have said repeatedly, this bill, the PRO Act, does not change current practice. We have also had a lot of discussion and discussed how this is, in many ways, the discussion itself is not based in reality. This is not what happens. And unless we're hearing that this is actually a thing, that a 10-year-old would come and ask and say, hey, I want to get us become sterilized. This is just a sort of hypothetical discussion that we're entering into that I just don't feel is very grounded at all. We've had some attempts to reground us, and we've also heard some really compelling information that people shared with us about reasons that some kids really shouldn't and can't trust the adults in their lives, certain adults in their lives, with really important things, including reproductive health care issues, and that those kids will seek out a safe adult, the safest adult in their life to be able to trust. But again, the PRO Act doesn't change current practice. Thank you.
Senator Limmer.
Thank you, Mr. President. If it doesn't change current practice, Senator McEwen, could you tell me what the current practice is?
Senator Limmer, are you asking Senator McEwen to yield for a question? Senator McEwen, will you yield for another question? She will yield.
Thank you, Mr. President. And so the question is, what is current practice? Again, I've also repeatedly said that I am not a medical doctor, so I guess I will have to defer to what the current practice is around this sort of fictional idea of a 10-year-old seeking sterilization.
Senator Limmer.
Thank you, Mr. President. Well, I'm rather surprised that the chief author of this important bill, who continues to make reference to current practice, fails to know what current practice is. And that leads me to a very serious question, and that is, what other issues are we not going to get details on? I personally believe, as a parent myself, parents have a right to know what's happening to their kids. They have a right to know a medical practice. They have a right to know how to protect their children from any kind of abuse, even if it's self-inflicted. This bill does not go in that direction. I'm rather surprised, again, that the chief author does not know this question, despite the fact that she continues to reference it. The very reason why we should be voting for this amendment. Thank you, Mr. President.
Senator Duckworth.
Thank you, Mr. President. And I promise my comments are to the amendment. And I very much agree with what Senator Limmer just had to say about the fact that there are some things that it's just obvious that parents should probably know regarding their minor children. Not only that the child might be considering or doing it, but they need to know about it because of the ramifications that child might have to live with as a result of that decision. I can speak from experience. As a minor, in order to join the United States Army at 17, I had to get the permission and the consent of my parents. The recruiters came to my house. They sat at our kitchen table. I begged and pled with my mom to agree to send me off to boot camp. basic training, and thankfully she allowed, but she said you got to go to college pretty quickly thereafter. That was the bargaining chip. So there are certain things that undeniably parents should know, be able to consent to, or have a conversation with their child about. And I would say in regard, it is heartbreaking to know and understand that there are children out there, there are minors out there that don't have, in some instances, an adult or a guardian they can turn to and trust that have their best interests at heart. But thank goodness that's a minority of children out there. And I would wager that the fact that those heart-wrenching instances exist shouldn't outweigh the right of other parents who are caring for their children and looking out for their best
Point
interests.
of order, Mr. President.
For what purpose do you rise?
Thank you, Mr. President. I rise to a point of order. I respect Senator Duckworth, but we are asking members to stay to the A120 amendment, which is not a parental notification amendment. Thank you, Mr. President.
Senator Duckworth.
Thank you for the reminder, Senator Friends. To the amendment. It's been said this just doesn't happen. That this is a made-up notion by Republicans that this could even be a potential. So my question would be, at what point does it no longer become fictional? Is it at age 11, age 12, age 13, 14, 15, 16? At what point is it no longer fictional? That minor children might be seeking to do this. And I ask that because one of the many issues that we've been discussing as a legislature over the most recent years is what certain kids might be beginning to experience and question about their bodies and some decisions they might make regarding it as a minor. So please don't try to let the public think that this isn't something that's not happening. These conversations, these thoughts, these considerations are running through the minds of minors in Minnesota, and that's why this bill should be very clear and specific about what's allowed and what's not allowed. And I think we've identified pretty convincingly it's not clear. And then it becomes incumbent upon us to vote yes for this amendment to add that clarity and to add that safeguard. So please, members, vote in support of this amendment. It's so common sense and reasonable. Let's do it.
Seeing no further discussion, the Secretary will take the roll. Senator Kunis, for those voting under Rule 40.7.
Mr. President, Senator Pa votes no.
Senator Pa votes no. The secretary will close the roll. There being 33 ayes and 34 noes, the amendment is not adopted. Senator Abler.
Thank you, Mr. President.